Well, next, People v. Philip Hutchinson, file 25-6994FH. We are scheduled here for sentencing, and also we had a pending bond violation contempt matter. Counsel, you want to state your appearances, please?
Mr. Goodrich, Wayne County Prosecutor.
William Key on behalf of Philip Charles Hutchinson, the defendant.
All right, and we're here, it looks like sentencing on a couple misdemeanor counts and an attempt felonious assault, a high court misdemeanor, guidelines of 0 to 9. Have you had a chance to review the report and recommendations for people?
I have, Your Honor.
And do you have any additions or corrections?
On the scoring, Judge, we would challenge offense variable number 1. Offense variable number 1 was scored in this case at 25 points. It's our position in this matter that it was scored indicating that a firearm was discharged at or towards a human being. The firearm in question was a shotgun. My client is a member of the local rifle club, was an 11-year member of the United States Navy. It's our position that he never pointed the gun at the victim in this case. He fired the gun, putting the victim in fear, and we never disputed that allegation. There's never been a charge here of attempted murder or assault with intent to create great bodily harm. I think that there's really no evidence to back up that the weapon was fired at the victim in this case. So it would be our position that that should be scored at 0 and not 25.
Ms. Goodrich, your response?
Your Honor, I believe from the description of the offense narrative, I wasn't aware of this objection, so I'm not.
So,
That it was alleged that he at least fired the weapon in the direction of the person. I guess it wasn't right at him because then the bullet would have hit him, but it was in the direction of the person.
all right, and in this case, law enforcement is dispatched to report of an armed gunman trying to shoot at people. Then it looks like there had been some dispute between these folks, and particularly with the plea that was entered, the defendant, while he was intoxicated and therefore wrongly possessing a weapon while he was intoxicated, did fire that into the air to intimidate or scare the victims. Had he pointed the gun at them and discharged the gun at or toward them, I got to assume that the prosecutor would not be offering a delay of sentence, that I wouldn't be taking it, and that there'd be, that would change the whole game. If he had leveled that firearm at these folks and pulled the trigger, that'd be an entirely different case than what I understand to be the case that we're here in front of today. So I think there's certainly some play in the discharge at a human being or discharge toward a human being. I'm not sure what work the word toward does there. I do think that there's an option for 15 points of a firearm being pointed at or toward a victim. And I think toward means something that's not directly at, like in a line of fire, but in their general vicinity or direction. And so I do think that on these facts, I think there's a preponderance that the firearm was pointed toward. Well, but if it was pointed forward, it was discharged toward. Yeah, I think this is, as I said, I think there's some room in the guidelines where it doesn't have to be a sharp shooting kind of skill. But again, in this case, I got to think this is not a case where somebody fired a gun at the people, or we wouldn't be here on a prosecutor's delay of sentence. So I think given that pushes me over the hump, to sustain that objection and score OP1 at 0 points. Any additional scoring challenges from the, that would bring it down to 5 points, which would be level 1. What range would that leave us at, Mr. Keough?
0 to 3, I believe, Your Honor.
Okay, thank you. Any other scoring challenges from the defense?
No, Your Honor.
Ms. Goodrich, any scoring challenges from the people?
No, Your Honor.
Mr. Keough, what would you like to say on behalf of your client?
Additionally, Your Honor, we just have one other
I'm sorry.
modification, as not scoring,
Okay.
just in regards to page 1 of the report. Under personal history and physical handicap, my client does indicate that he has titanium in his knee. He is disabled and he does have a knee issue, so we are positioned that he does have a physical handicap in regards to his knee. So we would ask that that be changed from no to yes.
Well, he had a knee surgery, and that's indicated in the physical health narrative. But I think under personal history for physical handicaps, I think that's intended to flag some, more profound sorts of disabilities to alert courts and the Department of Corrections for accommodations that need to be made. So I think I'm not going to order that change to be made. And the physical health narrative does seem that it does encapsulate
That's
the
correct.
information that you outlined. Any other modifications?
No, Your Honor, that's all we have for the report.
Okay, any allocution on your client's behalf?
Yes, Your Honor. In regards to Mr. Hutchinson, he comes to the court. He is 56 years old. This is a man who, up until this point, had only one prior conviction that was for impaired driving back in 2019. No prior history of assaultive behavior. This is a man who served 11 years in the military in the United States Navy. And for many, many years, he was fully employed, some years as a lineman. And if you take a look at his long history, he really was fully employed most of the time up until he was disabled. This case really is just an indication of somebody who handled the situation very poorly, and somebody who was at home on a Sunday, he was watching the Lions, he was excited about the Lions, he was drinking during the game, and a couple of people came over to his house. I don't think he had any intention of any of this happening. He observed a couple come over, and he observed the man being ignorant and abusive to his partner and handled it completely improperly. Couldn't have handled it probably any worse. Probably could have handled it worse, but didn't handle it. And he made the mistake of, in an intoxicated state, grabbing his weapon, telling the guy to get off his property after he was in a physical assault, and fired the gun in the air to get him off the property, put fear in him, and did it improperly. It was not appropriate. I've talked to him about this. He agrees it was inappropriate. I think this is a series of events that happened and he handled badly. And I think the crafted plea agreement really takes into account that this is an aberration rather than any kind of course of conduct in his case. I know that he has no prior history of assaultive behavior. You would think at 56 years old, he'd have something, but he has nothing. So it'd be our position that the plea agreement is the right way to go forward with this sentencing. I think it gives him the opportunity to avoid a felony conviction if he's successful on probation. And if he's unsuccessful, then he gets the felony conviction. So I think that the recommendations are appropriate. We would ask the court to adopt them in their entirety. And I thank the court.
Thank you, Mr. Hutchinson, it's not required that you would say anything today, but it is allowed. Is there any statement you want to make, sir?
No, Your Honor.
Okay. Ms. Goodrich, any recommendations from the people?
Yes, Your Honor. The defendant is 56 years old with no prior felonies and one prior misdemeanor, as Mr. Keough stated. I think alcohol influenced his decision-making that day at a 0.112 PBT. We're also here on a tampering with scram device. He has, looks like PSI served 30 days in jail I would just ask that the scram continue as a condition of the probation.
Okay. All right, Mr. Hutchison, if you please stand for the court sentence. I guess we do have the pending contempt matter. He has sat for 30 days, well, 28 days on that. I'll dismiss that contempt citation at this point, and we'll just sentence on the underlying case. And although we do have what I deem to be some post-plea misconduct, I wouldn't have to follow that agreement, and you would have lost the right to withdraw the plea. But I think on the whole, the plea agreement is still appropriate. And you did do about a month in jail on the violation of the bond issue. So I am going to follow the plea agreement and the recommendations of the Department of Corrections and place you on a 12-month delay of sentence on these charges. During that delay, you have to follow the conditions set forth on pages 2 and 3 of the pre-sentence report. Those include a substance abuse assessment and treatment as recommended by your agent. They include no contact with the complaining witness in this matter. It includes a crime victims assessment of $130, court costs of $350, DNA testing with a $60 fee, $168 in state cost, a monthly supervision fee to the Department of Corrections. And I think given that you do have an impaired driving in 2019, alcohol was involved in this case with a firearm. And also we did have some bond issues with that. I think I will direct that your first 90 days on the delay of sentence probation, you'll have to be on the electronic monitoring for alcohol scram tether. Good news for you. I think that when you're on probation, the Department of Corrections funds that, as opposed to when you're on bond, you fund it. If I've got that right, I think it won't be a financial impact for that. I think there's a monthly fee. Your monthly supervision fee increases, I think, from $30 to $60 when you're on electronic monitor. Still cheaper than you paying for the bracelet, but it will impact that. So then, because we're delaying the sentence, then I'm not going to impose any additional jail, and because we're dismissing the contempt citation, we'll get that delay paperwork done so that you can be released from the jail. Within 24 hours of your release, you'll have to report to your supervising agent so that they can get you going on that scram tether. Okay. And Ms. Goodrich, are we forfeiting any of these firearms?
Yes.
Okay, so any of the firearms that were seized, well, I can't really do that without entering a judgment. Are they still in the possession of law enforcement?
One, I believe there's one.
There's one.
Yeah, so
Okay,
it would just
so-
be the one gun.
Okay, and
That was
because
used.
it's a delay of sentence, I'm not issuing a judgment of sentence at this time for it to be an actual forfeiture judgment. So you may want to see about submitting a stipulated order forfeiting that weapon.
Okay.
Yes, Your Honor.
Okay. All right, anything further for the people?
No, Your Honor, thank you. Well, not.
Not old habits.
Flashback.
All right, you're all set, Mr. Hutchison.
Thank you, Your Honor.